State is proceeding on count 2, which is possession of a controlled substance, penalty group 1, 4 to 200 grams. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
George Schaefer for defendant, Your Honor.
And are you Ms. Allman?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
I have.
Court will find that the state is in compliance with discovery. Ms. Allman, I'm showing you what's entitled application for deferred adjudication. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We're waiving count 1 and proceeding on count 2, Judge.
Any objection?
No, Your Honor.
Ms. Allman, I'm showing you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand the state is proceeding on count 2, which is possession of a controlled substance, penalty group 1, 4 to 200 grams. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 20 years in prison and up to $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
She is, Your Honor.
Ms. Allman, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on count 2. There's a $500 fine. State recommends deferred adjudication. There's $50 restitution for drug testing. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Judge, I believe the amount of restitution was 57, but whatever it is.
You're right, 57.
Sorry.
I was trying to give her $5 back. All right. So do you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your community supervision be for a term of 8 years. There be a TAP evaluation, 100 hours of community service restitution, and a drug court evaluation. Did I read that correctly?
You did, Your Honor.
Judge.
All right. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
All right. And just so the record is clear, 57 is written down. I just read it as 52. All right. Then to the offenses charged in count 2, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
State offer states Exhibit 1 in all attachments.
No objections,
You
Your
may
Honor.
continue. Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? You need to speak up.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
There is, Your Honor, with respect to the community service hours that the state is recommending. This person was in a car accident. She's had brain surgery. She's currently disabled and probably unable to perform any community service. I would ask the court to allow her to provide the probation department with proof of those things. And if so, we would ask the court to waive the community service.
Okay, so when did this accident occur? Was this before or after this incident?
It was before. It was before the incident, but I've been sick. I have 2 brain aneurysms and I've been disabled since 2004.
This is the legal pressure point of the case. By pleading no contest and requesting deferred adjudication, Alman avoids an immediate guilty finding. But that relief is conditional. If probation is ever revoked, the court can sentence her, as if she were found guilty today, up to the full 20-year maximum. Deferred adjudication is not leniency. It is a high-risk alternative that places complete control in the court's hands.
Okay. I can tell you right now, felony drug court is not going to accept her
I don't
because
think,
of the nature of the police report.
yeah, I don't think they should, Judge. As a candid matter, the drugs in question belonged to her boyfriend at the time, a David Casares, who entered a plea of guilty already and has been sentenced.
Mhm.
I don't think they'll accept her, one, because she doesn't use drugs, and those were not for her
Just cuts
use.
them.
Sorry,
According to this, just cuts them.
according to the report, that's
Yes.
true, Judge.
Okay. All right, this is what the court is going to do. There's a $500 fine. That will be probated. 9 years deferred adjudication
I'm sorry, the term was 8, Judge, but
outside the agreement. So there'll be 9 years deferred adjudication, $57 restitution to the lab for drug testing, 100 hours of community service restitution. If she provides medical proof that she's unable to perform those hours, then the court will reconsider. So you need to provide whatever medical proof to probation. All right, there's to be no contact with David Casares, Casarez. Regular reporting by Zoom or in person. Random regular UAs. Proof of employment or disability within 45 days. There should be no employment as a home health care provider or with minors. There should be no unsupervised contact with minors. TAP evaluation that can be done out of custody. Follow TAP recommendations. Random field visits with a minimum number of field visits once every 3 months. Probation, is there anything else she needs?
No, Your Honor.
Is there anything else you need from the court to be successful? Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. In this court, in order to be successful on probation, communication is key. If there's an issue, address it with probation. If you feel like they're not addressing it, then you can always come back to the court. You understand?
Yes, ma'am.
And here's the other thing. You cannot build your happiness off somebody else's misery. And whether your boyfriend was doing this and you participating, all of y'all were building your happiness off somebody's misery, trying to make fast money. And that's not the way to live your life. You understand?
Yes, ma'am.
All right, good luck to you. Court is calling 2023 CR 1475 State of Texas versus Larry Haynes. Can I have the parties approach and announce for the record for the state?
Judge Boyd ultimately grants 9 years of deferred adjudication probation, imposing strict conditions, financial penalties, employment limits, and no contact orders. Then comes the real message, one that goes beyond sentencing. The judge frames the offense as part of a larger harm, rejecting the idea of a victimless crime and warning against building a life on someone else's suffering. This ruling isn't about mercy or punishment alone. It's about responsibility. If you think probation is getting off easy, does this case change your mind? Drop your thoughts below and follow for more real courtroom breakdowns like this one.